As you may recall from another lesson, to attain holder in due course status, a person must be an instrument's holder, take the instrument for value and in good faith, and take the instrument without notice of various problems affecting the instrument's enforceability. We've already discussed the first three requirements. Now let's look at the last one. To be a holder in due course, the holder must take the instrument without notice of various problems affecting the instrument's enforceability. Under the UCC, notice exists if the person has actual knowledge of the fact, has received notice or notification of that fact, or has reason to know of the fact, considering all the information known to the person at the relevant time. The first two of these are fairly self-evident. Actual knowledge means subjective awareness of a fact. So if a person signs a document, that person is generally deemed to be subjectively aware of everything in the document. Similarly, a person is deemed to have received notice of a fact if the fact either comes to the person's attention or someone duly delivers it in a reasonable form under the circumstances. As to the third, courts have developed two tests to determine whether a person has reason to know of a fact: the duty to inquire test and the inferable knowledge test. The duty to inquire test finds notice if a reasonable person, knowing what the holder knows, would have made further inquiry or investigation, and in so doing, discovered the fact. Under the inferable knowledge test, a person has reason to know of a fact if, based on all information known to her at the time, the only reasonable conclusion is that the fact exists. Because this test imposes no duty to investigate, it sets a more rigorous standard for finding notice than the duty to inquire test.